What are the main types of informal fallacies? Have you ever heard an argument that just didn't sit right with you? It might have been an informal fallacy. These are errors in reasoning that can sneak into discussions, especially in legal contexts. Understanding these fallacies is essential for anyone preparing for the law school admission test or studying law. Let's break down the main types of informal fallacies you should know. First up is the ad hominem fallacy, which means attacking the person instead of their argument. For instance, if someone says, "You can't trust her opinion on law, she has a criminal record," that's an ad hominem. It distracts from the actual argument being made. In legal debates, this can undermine the credibility of witnesses or opposing counsel without addressing the core issues. Next, we have the appeal to ignorance. This fallacy claims something is true simply because it hasn't been proven false. For example, saying, "No one has proven he didn't commit the crime, so he must be guilty," is misleading. In law, the burden of proof lies with the accuser, not the accused. Then there is begging the question, also known as circular reasoning. This occurs when an argument's conclusion is included in its premise. An example would be, "The law is just because it is the law." This doesn't provide any real justification and weakens the argument. Another common fallacy is the false dilemma. This presents only two options when more exist. For instance, saying, "You are either with us or against us," oversimplifies complex issues. In legal reasoning, this can misrepresent the facts and lead to poor conclusions. The no true Scotsman fallacy is about redefining categories to exclude counterexamples. For example, saying, "No true lawyer would argue that way," dismisses valid arguments by narrowing the definition unfairly. This can lead to ignoring legitimate legal perspectives. Another one to watch out for is the slippery slope fallacy. This suggests that a small first step will lead to extreme outcomes without evidence. For example, claiming that allowing one type of evidence will lead to chaos in the courtroom is a slippery slope argument. It can be used to resist legal changes based on unfounded predictions. Lastly, we have the definist fallacy, which involves unfairly defining terms to support a controversial position. For example, if someone redefines legal terms to make their argument easier to defend, it can mislead others and obscure the real issues at hand. Recognizing these informal fallacies is key for law students and anyone preparing for the law school admission test. It helps in analyzing arguments critically and constructing stronger, more logical points. By mastering these concepts, you will be better equipped to tackle the logical reasoning section of the test and succeed in legal practice.